Making good progress.
Right, we're table. Commissioner Adaro. Commissioner Adaro. Commissioner Adaro, are you there? We're trying to take roll and we want to make sure you can hear us.
Yes, I'm here. Thank you.
Commissioner Kasher. Commissioner Wasserman.
Here.
Commissioner Wynn. Here. Chair Remke. Here. And just to clarify, so Commissioner Kasher is not on the phone. He's not participating. He had a conflict. But thank you. And Commissioners Wasserman and Odero, just speak up if you can't hear us or there's any problem, and we'll pause and make sure we're getting good communication, because we are having some phone problems today, and which means nobody could call in, and if they wanted to watch this outside of here, they had to watch it on YouTube. Is that right? And we tweeted that out or something? Okay, great. All right.
Okay, and this is Commissioner Adaro just confirming we hear you fine.
Great, thank you. Okay, so I will just start by giving a quick overview about our revision project, which we are very excited about. We have now had, so anyhow, the first draft is posted on our website as well as California Forward's website. We have had two public hearings, one in LA and one here in Sacramento. Next week, we will be going to Oakland City Hall, and you can see the address and location again on our website, but that is Thursday at 1 p.m. in Oakland. We would love as much participation as possible. That is this phase of the project, trying to get as much input and as many suggestions and comments as we can. I'm pleased to report that right now I think we're getting a lot of positive feedback. We've heard a lot of support for the goals of the project. A lot of people stepping up and saying that they agree the act is unnecessarily complicated. It makes it difficult to run for office. So we feel good that we're on the right path, and now we just need as much input from others. So please take time to go ahead and look at the draft and make your comments. So that's that. Any other public comment before Commissioner?
Yeah, I have a quick comment. I just want to acknowledge that Capital Weekly this month said that Jody Remke, our chair, was one of the top 100 influencers in Sacramento, and I think they acknowledged her leadership and hard work, and when she looks good, we look good. So thanks very much, Jody.
Thank you. And to the extent I look good, it's only because of all of you, and in particular staff, and they're doing a great job. So thank you to everyone. Okay, any other public comment? Not about me. Okay, seeing none, we're going to go ahead. We have item number 2 are the minutes from July. Commissioners, any comments or corrections on the minutes? Is there a motion?
I move to approve the minutes from the July 2016 meeting.
This is Commissioner Adaro. I second.
Commissioner Adaro?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Remke? Yes, this motion passes. Great. Okay, next we have the enforcement consent calendar items 3 through 14. And we'll first talk about whether any items need to be pulled. I know that we will have probably a pretty good discussion on item 3, so I'm going to go ahead and pull item 3. Any other items need to be pulled?
This is Commissioner Wasserman, number 4, please.
Okay. And again, just to clarify, pulled not because of wanting to comment, but perhaps a conflict of the like. But okay, so 3 and 4, any others? Okay, so then as to the remaining items 5 through 14, do we have any comments or questions from the commissioners? I think I did. Oh, I just wanted to highlight is number 5. And I hope the other commissioners just took note. I think we talked about this earlier as far as enforcement division's pre-election efforts, and this case is a good example of that. And what occurred before the election, which was the press release where the committee acknowledged that they failed to comply with the disclosure, proper disclosure. Ms. West?
That's correct. Galena West, Chief of Enforcement. This was part of our pre-election efforts for the June election. We reached out to committees that had a lack of identification on signs, and we either they had the choice of correcting or doing a press release with us that was put in all the local media through our press office, and in order to acknowledge that they were the centers of the sign and get the notice out to that jurisdiction so that they would have the disclosure.
So it's a great program because not only do we get the disclosure before the election, it didn't preclude obviously your ability to continue to look into it and then enforce the violation too. I understand that that's one of the reasons maybe this fine was a little bit lower than even normally, but that's because of their cooperation and the disclosure pre-election.
It was. It's in line with the anyone who corrects before the election and remediates the harm.
So that's great. And I'm assuming we'll be doing similar pre-election activity, and you can bring us up to speed maybe in a month or two on that. Okay, is there a motion or any other, oh, sorry, go ahead. Yes. Is there any public comment on items 5 through 14? 5 through 14. Okay.
So I'd like to go ahead and move approval of the consent calendar, items 5 through 14.
This is Commissioner Wasserman. I will second that.
Commissioner Adero,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes, this motion passes. Great. Okay. So we'll take up item 3, in the matter of Tina Baca Del Rio. And Ms. West, if you can just bring us up to speed since this was last on the agenda last month.
Certainly. Galena West, Chief of Enforcement for those on the phone. Hello. So as tentatively agreed to at the last hearing, the settlement that we stated on the record was what we put forward with Ms. Baca Del Rio. She took responsibility for her actions. She made her payment in full, which included $15,000 from her personal funds, which she provided proof of, and her filings are complete. She also came up to date with Secretary of State and paid all her annual fees. And so this negotiated settlement is in line with what we tentatively agreed to then. And so now it's been memorialized. As you can see, the biggest difference is in the 24-hour reporting, which is very consistent with how we do settlements for 24-hour reporting, as opposed to charging it per contribution. We generally group them in terms for settlement, but that's fine. If you notice, from the default was 4,000 per, and now it's 45 per account for that to make up for bunching. So that's part of the settlement. And I think that this really reflects our priorities of acknowledgement of wrongdoing, complete filings, and just having the payment in full with that responsibility taken.
And so just on the, I think the biggest difference is the counts regarding the 24-hour reports. And so I noticed there was another matter on the agenda, which was streamlined, so it's obviously different for a lot of reasons, but normally 24-hour reports are fairly low fines, as you're saying.
Yes, 24-hour reports, if they're in streamline, they're reported as a count per statement, per 24-hour report due, and it's a $200 fine. But when they're in an exhibit as part of settlement, they're generally grouped by either a month or a time period where there's a group of them within a certain week. And as these are at the threshold, which is $1,000, These aren't the types of 24-hour reports that are 10,000 or $1 million reports. So generally, as part of settlement, we would group these. So
Yeah,
this is
because the
consistent with
total,
that.
even though there are 22 of them, it's only $22,000, right, only, but, okay.
And they were also disclosed on her campaign statement.
That was what I was gonna ask. So that's the issue with the 24-hour reports. Obviously, it's an important issue, and we want the immediate disclosure, but in this case, she did, although not filing 24-hour reports, she did disclose it on her campaign statement. True. Okay. All right, and any, questions from the commissioners? Commissioner Wynn?
Hi, this is Commissioner Darrow. I have some questions. So I'd like to discuss a couple of things about this stipulation. Number one is the reduction by a full 50% from what we all, I think, said we're ready to approve last month. Number two, I think that all of that comes from the agreement that was reached in the stipulation seems to come from a directive that was given to enforcement by the commission some time ago, certainly predating me, I don't know, predating anybody else, regarding how to enter into these stipulations and what discretion enforcement has. And so I understand that enforcement is constrained by that directive, but I'd like to use this opportunity to discuss that because I think that there is a kind of a philosophically different way of approaching this, and I'd appreciate hearing the other commissioners' thoughts as well as enforcement's thoughts about why a reduction in the penalty better fulfills our purposes as a commission than a reduction in why a reduction in the counts, in the number of counts, better fulfills our goal, our mission, than a reduction in the penalty. The way I see it, and I certainly can be convinced otherwise, but the way I see it is, if we reduce the counts, but maintain the highest level of penalty, I think what we're messaging is to the regulated community, hey guys, this is a big deal. We take this very seriously. We believe that the highest level of penalty should be assessed. And I think that that's a worthy message. At the same time, to do that, we are also messaging to the public, there aren't as many violations here as there actually were. And so I guess the question is philosophically, how did we get there? And how does that really, why is that the better approach than to keep the number of counts correct so that the public knows this person had, as we had last month, 24 violations, rather than now under this approach, the public sees that this person only had 12 violations. And kind of along those lines, if we have a person that only violated the act once, we're not reducing the counts by a half, right? We're not saying there was a half a violation. That person will show one violation on his or her record. So compare that person to person number 2 who violated, let's say, the same part of the act, but twice. In order to enter into a stipulation with that person, under this philosophy, we would be reducing the counts to 1. So I, as Josephine public, I guess, will see that person 1 violated the act once and person 2 violated the act once, which is not exactly accurate. So I understand that enforcement is limited by an earlier directive, but I'd like to have a discussion among the commissioners as well as enforcement as to what is the best approach here.
Do you want to hear from enforcement first, Ms. West, or did you want to hear from the commissioners, the other commissioners and their thoughts on this? I wasn't clear.
Either way is fine with me, it doesn't matter. I value all of them equally.
Okay. So why don't we start with Ms. West from enforcement? I guess I would ask for a little bit of clarification on, because I'm not sure what directive you're referring to other than when we talk about serious violations should keep at the maximum penalty and flexibility on the number of counts. I think that's one premise.
Yes, that's,
Okay,
yes,
okay.
that's exactly what.
But I think the bigger issue and the concept for me, which I guess I'll just state, I find this perfectly acceptable settlement in light of past activity we've taken. I think about the Strickland case we recently, when that was a default to a settlement, it was cut in about half. I think there's the posture, the starting point of this case, which is very different. You have to remember it was a default. And not that we're going to try to jam someone up with as many violations as possible, but the reality is there's no one opposing the situation. Therefore, you do look to every violation. Why? We're not going to negotiate against ourselves and give someone a break who hasn't even shown up. So I think this is a unique case where you have to remember you're starting from a default, no cooperation, no opposition, no response, to a stipulated settlement, which, as Ms. West points out, the most important factors being acknowledgement of wrongdoing and compliance with filing. So those are, to me, the opposite ends of the spectrum, and probably in the middle is a contested case that goes to hearing where a neutral party is going to come up with weighing the factors and coming out with an amount. But to me, we have these opposite ends here. There's that I think is a big difference, and I also think that it's not so much about keeping the highest penalty and reducing counts just to reduce counts. I do think personally that this settlement looks a lot better and is a lot more reasonable than the position of a default where we don't charge 24-hour reports for each report. That's just not the pattern of practice. We never charged as much as $4,000 was the original one on the $50 fee. I mean, the $50 fee thing is new, and they're mostly streamlined at $200. So again, I mean, I think this settlement, and at $55,000, that's a pretty high penalty for our cases. Look at the agenda. Look at the last year. This is on the very high end as well. And for what appears to be not a very sophisticated individual based on her practices. Now, that's not that she gets a pass and she should get off, but I think we take that, or should take that into consideration as well, versus other respondents where there's a high level of sophistication and more of an intent to conceal or do wrongdoing. So I'm just rambling on into all the reasons why I think this is a good thing, but I think it's also just the point about settlement. And the bottom line is, like any adjudicatory process, we do not have, and I get in trouble when I say this, but we do not have the resources to go to hearing on every case. It would not be a good use of public resources. It would not be a good use of our time. It would give us a backlog. I mean, this is a way to move cases in a fair process. But
I understand that, but I think we're talking about different things. I wholly support and commend enforcement for reaching stipulations on such a large number of matters. Because I do recognize that we don't have the resources. I'm not talking about that. I am talking about when we reach the stipulation, what is it that we are telling the public and the regulated community about the thought process and the analysis and what actually happened compared to what we're telling the public. So for example, in this stipulation, which I applaud that we reached, don't misunderstand, But in the stipulation, we are now telling the public that there were 12 violations, when in fact, there were 24.
But can I just
Right?
jump in there, because I think that's the point of the language, and I think it's we'd be simplifying the process too much by just saying 12 counts equals $55,000 penalty. It's the facts and circumstances surrounding those, and all 22 late 24-hour reports are listed. The amount of each report is listed. So I don't think anyone is walking away thinking that 12 counts equals 55,000 is the full scope of the case. I think the facts of the stipulation show the full scope of the case. That's my thought on that. And I really well let Ms. West talk.
Hello. So this is the direction that we take. Is the whole reason for the Streamline program was so that every violation was identified in a manner to where a proper fine could be issued and all the counts could be included. When you have a campaign case, and probably shouldn't acknowledge this, but with the rewrite going, I guess it's okay. You could have 100 violations of the act. When you do a campaign and you sign on as treasurer and you've never done it before, you will miss occupation employer. You will file something late. You're going to miss a report. You're going to identify yourself wrong on a mailer. You're going to make mistakes. When Franchise Tax Board does an audit, they look for substantial compliance. They don't look for perfect compliance, and they look for substantial compliance. It's a strict liability area of law. So you're going to have more counts, more violations than you would ever charge because of prosecutorial discretion and common sense application of the law. And so when we take that in consideration as our base, then we also look at the very serious violations. We get to those and we say, how big a range do you want enforcement to be able to have as you're enforcing action? Do you want us to have a range of 0 to 5,000 on the more serious violations of the act? Is there any time that you would see a violation of laundering, for instance, that you would say, well, that's a $200 violation of laundering? And the commission has historically, and I think this is what you mean by direction, commission has historically said no for conflicts of interest and for money for laundered campaign contributions. They traditionally said these are the more serious. Your range is limited enforcement. We will not, and they say that by not approving stipulations. So when we bring a stipulation and we charge, for instance, on the one that was pulled by Mr. Wasserman or Commissioner Wasserman, we have this at one count for $5,000. It's a perfect example. There's 2 contributions. We could have brought it for 2 counts at $2,500. And this, I think this one is more on point than Baca del Rio as to what Commissioner Odero's point is. This is the difference. We didn't bring it at 2 counts at $2,500. We brought it at 1 count at $5,000 because the direction through rejected stipulations has been we don't want to see laundered campaign contribution cases at $2,500.
But I think the question would be, the next question would be, well, why didn't you bring it at 2 counts for $10,000?
Right. Because then you have the circumstances of the individual, the sophistication, and all of the things that you were talking about, Chair Remke. And so,
and why wouldn't they just contest it and go to trial at
right,
that point?
and then they would have no benefit to settlement. And in the story, we have told that there are 2 contributions, and we go into detail about that. And that's actually what has changed over the past 2 years. We've told more of the story. We've put more of the other violations in so that you can see a pattern of aggravation. One of the factors that the commission takes into consideration when determining the fine that we include in every exhibit is pattern of violations, pattern of activity. Not only did you get advice, but is there a pattern? What's their level of sophistication? What are we talking about here? So there is a difference, but it's only a difference in the more serious violations where we've gotten this direction to consolidate. But I would say that if we did start charging more counts, the campaign landscape for charging counts is endless. And so for conflicts of interest, this isn't going to be as big a problem because you're usually talking about one decision or two decisions and you get charged for all your decisions, with a rare instance of them being linked and being charged in one count. But we're talking basically about campaign. This is a campaign issue. And so when we're talking about considering charging more counts, there's quite a few that could be included in that. When you the commission, when the occupation and employer section first started in, I think it's 85700, and it said that you not only have to disclose occupation and employer on your campaign state, but now here's a new law that says within 60 days you don't have that information in your file, you also have to return it. So it was a new law, and the commission said go for it. So we were charging, not only you didn't report it, but now we're charging you had to have returned it, and we were making them return the money. So you would get 3 violations every time you didn't have occupation and employer on your campaign statement. And so the direction at the time was charge them individually. So each contribution that didn't have it got 3 charges. And so it goes back and forth. And then the commission said, why are you charging this 3 times? So then it went back to, well, this should be by campaign statement, and they should be combined into one charge. So even though 84211, the disclosure, and 85700 are 2 separate sections, they're charged under one count. So I'm sorry if I got too far in the weeds there on that part, but that's what it is.
Commissioner Wynn has something to add?
Thanks very much, Ms. West. That really was a helpful description of kind of how we got here. And just to Commissioner Ardero, so when you said, I think maybe there was a directive from the commission to kind of consolidate counts, so that's not my perception. There certainly have been directives from the commission since I've been here 3.5 years. One is settle when appropriate and fair, and especially if you can get compliance. In default cases, impose the maximum fine. And that some penalties are more serious than others, and we don't really want you to stipulate down on those. So those are the directives from the commission as long as I have been here. And I certainly understand why Commissioner Ardero thinks maybe there was a directive to reduce counts to get settlement, but I do think it's more combined in that first directive, which is settle when appropriate for compliance. So anyway, that's my perception.
Can you hear me on this? This is Commissioner Wasserman.
Yes.
So the directive or direction, or however I want to phrase it, I think it does exist. That we did indicate that we that the reduction of counts versus the reduction of fines was what was preferable if appropriate. But I guess we interpret how that's phrased as whether that's a directive or direction differently. But you know, I have this question related to Commissioner Ardero's concern, and I guess it goes to 3 things, I suppose. What acknowledgement of wrongdoing are we really attempting to achieve? And we can say that the facts are in the narrative, but the simplest disclosure with respect to, you know, what the stipulated violations are is in the count. You know, when it comes out for the public to take in, to process, to consider, when evaluating the people in which they place their trust, it may be of more value to see, you know, this person or that person has, you know, 2, 3, 4 violations rather than 1 violation, versus the question of what is, you know, whether or not the level of the fine as a deterrent or as a message is more important. And that's sort of, I think, the balancing that we're talking about, and I think is something that is worth thinking about. Well, actually, it's worth thinking about in every case. I think we do, but I think Commissioner Darrow's kind of put a point on that, and I was really going to try to dig into that on number 4 because it's such a more straightforward example. But you know, it goes also to the question. I mean, I respect the prosecutorial discretion, right? Because you charge every possible violation down the way, that's probably not a good allocation of resources. It's also probably not necessarily fair, but the commission itself just needs to, I guess, occasionally return to the question of are we pursuing and approaching these things in a manner that best furthers the purposes of the act. And it's interesting. I want to make a small observation. When I was on my personal time in Alaska, and I saw the Alaska Public Office Commission with their fine, they had a fine system that charged a certain amount per day. So you had a violation that was essentially a $100 discrepancy, but the fine, if they imposed it as set forth, would have been something on the order of 400, 500,000. And they would just very regularly depart downward. I think first as a fairness matter, second as a constitutional matter. But it's the same kind of question we have: is at what point are we doing too much or too little in either direction, right? I mean, we could pile on, and I think Ms. West made a very, very clear observation about how the pendulum can swing. But I still think it's worth maintaining as an open question. And if it isn't a directive per se, and it's more a direction based on how we approach these things and how we decide them, I think it's an even fairer game to consider in each case, though I'm sure it would be much easier for enforcement if it came closer to a direction that was a directive in every case. Yeah, so I mean that goes back to it. The question is, what is more important for our purposes? The acknowledgement of wrongdoing and communication of it in a very clear and simple fashion through the use of accounts, or the acknowledgement of wrongdoing sort of in a broader sense, lumping some things together and reaching a fine that itself sends a message and hopefully a deterrent, both for the individual or committee that is going to continue to be operating within the public sphere, and for the others who presumably are paying attention. Where do we put our priorities?
I would say I would be hesitant to put our priorities on number of counts. I mean, there are just too many ways to play with that, and I don't think that is a display of success on our part or the strength of enforcement, because as Ms. West pointed out, you could pile anything on in a campaign case. I don't think we should be looking to, wow, high five, we got 50 counts. I think we should be.
I don't think that's what I'm saying.
No, I'm not. I'm not saying
but
that.
I do, because I think I don't think that's what I'm saying.
I didn't imply, I'm not done. I didn't imply that's what you were saying. I'm saying from my point of view, it's not an issue of counts. It's an issue of the nature of the case. And I would just say, for example, in this case, there were 4 categories of violations: timeliness and disclosure on statements, 24-hour late reports, $50 fee, and personal use of campaign funds. Now, those 4 areas of violations were in the default, and they followed through exactly into the settlement. So to me, what we should be focusing on is the nature of the conduct and the nature of the violations, and that we don't want to lose that. So again, I think maybe if we are concerned about what the public thinks about the number of counts, I think we're losing our mission. And it's kind of what you said, Commissioner Wasserman. We want to stay true to the act, and the act is someone can't file late, someone can't not do 24-hour reports. I mean, we're hitting the points and the emphasis on what the behavior should be. So I don't think this is about an issue of counts in one column and penalties in the other. I do think it's an overall more holistic approach to resolving these matters. And again, I just stress a $55,000 fine is on the top end of any case we get. So Those are my
Well,
thoughts.
I want to, sorry, were you finished?
Yes,
Madam Chair, did you complete your thought?
I did.
Okay. No, I mean, I think what, I don't want to speak for Commissioner Darrow, even though she's sitting next to me, could probably poke me if I started attributing things to her. But I think what is going on is we're taking this opportunity within the confines of this case to have a discussion about direction, that, you know, this is the only way we can have this discussion is in the confines of this case. But I think it's fair, given time and resources, that we do return to the actual case itself in front of us. I'm about to be poked, excuse me.
Although this is Commissioner Adero again, I do want to respond to something that was just said, which is we want to make sure we don't lose the nature of the violation as really what we're trying to communicate. And I would only say to that we don't lose. There is no way to lose the concept of the nature of the violation by not reducing counts. It's only by reducing counts that we stand a chance of losing anything, right? Because if we left this as 24 counts, the 4 types of violations would all be integrally there. So I disagree with that.
Well, can I just counter on that? I'm sorry, before you move on, let me just say why I would disagree with that. Because
She was moving on.
I wasn't finished with my thought, but
okay,
go ahead, Madam Chair.
no, I'm fine.
I don't think it's an issue of losing the nature of the case. I guess is all that I wanted to say. I don't think that leaving all the counts present causes us to lose any information that goes to the public about the nature of the case. And I do agree with Commissioner Wasserman that what we are trying to do is trying to come up with a workable balance. But I think that we have to get there through some guiding principles. And, I recognize that these guiding principles may change from commission to commission or commissioner to commissioner, even though they really shouldn't, because we're supposed to be following the act and staying true to the act. But clearly from what Ms. West has, the anecdote that Ms. West has provided, it does show that, as Commissioner Wasserman said, the pendulum does swing. But as we, as a commission, form and reform every year as one of us comes off and a new one comes on, I think that we need to keep true also to the commissioner's understanding of what our guiding principles are under the Act. And I do believe that there is greater transparency to the public by leaving the number of counts easily and readily available and accessible than to reduce the number of counts.
Hi, this is Galena West. I just wanted to respond about this case in particular. So in this case, it does seem like there's been a substantial reduction in counts. It does off its face because it was the default. And the main difference between the two is the 24-hour reports. So since 24-hour reports are a full 90-day period now, so I think this case may have been even before that. We're talking about 90 days of 24-hour reporting. And if we are given the directive that every single day has to be charged as a separate count, then the streamlined program fines are going to start bleeding into the standard fines. So we would have to find some sort of way to balance that. So this is just an observation that I'm putting forward. The only other difference for this case, there is one count of personal use not charged, and that is because Ms. Baca del Rio participated in the process, gave documents, showed us some evidence. That's why it's not a reduction in counts because of a settlement negotiation. So these are the things that happen when someone starts participating. We actually get evidence, we start talking, we get statements, and sometimes it changes from the default documents that you see. So it's not always a negotiation as so much as we have gotten participation. And then the other one is the annual fee that Chair Remke brought to your attention. It's uncharted territory. It's a $50 fee that we started with Secretary of State in 2013. And so for the default, it was charged as two separate counts, and for the settlement, it was combined. So that we're really just talking about 24-hour reports. That's what's been combined. So if that is something that you want to discuss and the 90 days would be charged individually, then that is definitely something that we should be given some guidance on what those fines would be.
Madam Chair, if I could just make a comment. So, while I respect Commissioner Ardero's, desire to really be transparent, and of course I want that too, but I don't see the benefit of, reporting 22 counts for basically the same violation when you can combine them to 4, get a more appropriate settlement, and, get compliance in the end, which is what we want. So that was one of the things that moved me toward agreeing with this stipulation. We got full compliance, and she had to put some of her personal funds in, which I thought was important. She couldn't just pay the entire fee or fine with campaign funds. So, I'm really satisfied that this is a good stipulation. I think this has been a good conversation, and I think we should have more of this, but I'm really comfortable with reducing the number of counts to get, a more rational conversation.
Madam Chair, this is Commissioner Wasserman. I have 2 more questions for Ms. West, if I may.
Yes.
So can you return to count 12, Ms. West, the prohibition against personal use of campaign funds? You said something which, I'm sorry, I think the idea of assisting budgetary constraints by having us call in this time, that has its challenges as well. I missed part of that. You said that because the respondent was participating, there were other facts that came to light, and could you re-articulate that or perhaps go into that a little further?
Certainly. I was actually talking about count 10, which used to be broken up into 2 counts. The count 10, as it was written in the default, was 2 counts where we talked about 2 different time periods of cash deposits where we had asked for supporting documents and statements from the respondent and had not received any. And it said it quite bluntly in the default that we had practically begged for information and not received it. And so once Ms. Vaca Del Rio started participating in the process, she was able to explain some things to us, which caused us to believe that this was 1 count and not 2.
Okay, so that's not even in the area of what we're discussing. It's really more on the lines of, okay,
Right,
this
that's
is not
why I
something
wanted
that we're
to
going
bring
to
it
proceed
up.
on.
Yeah, I wanted to bring
Okay,
that up to clarify.
Thank you for that clarification. My second question had to go to, I think what Commissioner Wynn touched upon that. And this has to do with, again, commission, I suppose I'll say direction rather than directive, with respect to how we impose the penalty individually or against the committee and the individual, and also how that payment is received. So the personal use, the personal use prohibition, I guess is the maybe I'm jumping to a conclusion based on the table, is the penalty that is actually assessed against the respondent individually. Is that correct?
The personal use prohibition, when the law changed, anytime you violate any of the personal use prohibitions under the Act, you can no longer use campaign funds to pay the fine.
Right. So that one isn't an area of discussion and stipulation. That's simply following the statute. So then we have proof which she has paid that $15,000 individually. I think you mentioned it, but I just want to circle back to it. She did pay that individually from personal funds. We have documentation of that.
Yes, I'm happy that you circle back to that, because it's such a key point that she had provided proof that she paid $15,000 out of her own personal funds and not out of her campaign account, and provided proof to the Bridget Castillo working the case.
Mhm. All right, because I think we've also had other situations where it wasn't dictated by statute how the division was set up, and perhaps that the settlement dictated it. And I'm always curious as to how that's eventually paid out. But obviously, this one is strictly by statute and has its own requirements for conformity.
It does.
Okay. You know, I have to say it is challenging to look at these things where you have folks who have, whether accidentally or intentionally, personally use their campaign funds, and then afterwards they have to pay individually. And I guess our inquiry stops there. If it comes from their personal funds and they present it as sworn as in the stipulation that that's personal funds, unless and until someone comes forth with a complaint otherwise, that's how it stands, I assume.
For personal funds, since it's required by the statute, we require them to show us that they're paying for personal funds.
That's right, but we don't do an inquiry further as to where the source of the funds that come from the bank account. We stop there. It's a personal account, personal funds, and they're stipulating under oath that this is their money and not someone else giving them money or something like that.
That's true. The standard
Right?
for
That's where our
obtaining,
inquiry ends.
correct. The standard for obtaining personal bank accounts is different than campaign bank accounts. So yes, that's where our inquiry ends, unless there's suspicion of other activity.
Right. Thank you for that.
Okay, do the commissioners have any other comments or questions? Is there any public comment on number 3? Yes, please come forward.
This is with Miss, thank you for having me here. I don't wish to be rude. This is with Miss Tina Baca del Rio, correct?
Correct. Can you state your name, please?
My name is Richard Hernandez. I live in City of Commerce. I came down here specifically for this hearing. Miss Del Rio has had 11 years of experience being a public servant, and with all the violations she's committed, I honestly don't think it's just to minimize a fine when she deliberately knows what she did. Now, I would imagine you had some kind of guidelines for her to follow with her campaign. So how is it that she wouldn't know anything about that? And since her starting, I believe in 2005, that she's had all these violations. And in some of the council meetings that we've had over there, questioning her about it, and her saying that the newspapers were biased, that they extend the truth, when actually it was her extending the truth. People wanted clarity. They wanted to know exactly what was going on. For such a length of time that she's been serving, I really don't think it is just that you minimize the charges, minimize the violations. She represents us as a city, and we look up to her to make the right decisions. Now, if she can't do that with her own campaign money, what is she doing for us as part of the council? And it really upsets me to hear all this, because up to present day, with all these with all this information that I have here, I don't think it's right. I honestly question her character as a person, as a representative to the residents of Commerce. I don't care for it. I don't like it. Sure, it would be nice for everything to be soft, but it's clarity. And despite the fact that she neglected these 24 hours, she has a responsibility. She's responsible for her actions. She's a public servant. And it should be that way. When she's asked questions at the council meeting, there's no clarity with that. And it's always an explanation that sounds so good, you would trust her just by hearing her. And unfortunately, I hate saying this, but it's just lies. She denies the truth, she smooths things over, and she deceives people. I really don't think it's right. And I wish she was a different person. I wish she would meet all of her obligations, but that hasn't happened. And I think it's totally unfair to us as residents to simply say, okay, you have 24 accounts. And it's understandable, 24 hours seems a little extreme, but the reality is what she's doing there reflects on her as a person of what she does in council. And I do not care for it one bit. I came all the way from Commerce over here for this. And it's really disappointing to have her as a representative knowing what goes on and her being questioned and just looking at it as it's nothing. She can get away with it. And it seems like she's getting away with it right now. I don't care for it. There's a lot of residents that are upset. Unfortunately, I don't think they can take this trip and come out here. It's like I did and a few other people did. But from present to past, they're all here. And I think you should go with default. That's basically it.
Thank you, sir. Any additional public comment?
Thank you for hearing me out.
Thank you.
Madam Chair, I'd like to ask a question of Mr. Hernandez, if I may.
Okay.
Sure, you may.
Well, first, Mr. Hernandez, thank you for taking the time to travel to our meeting, and thank you to the other people that you mentioned also came. It's important for us to hear from the public, and we very much value your comments and your thoughts. Further to the discussion that we've been having before you stepped up to speak, I'd like to ask you a question of what you, as a voter, a member of the public, a recipient of the information that comes out of this process, what is more valuable to you when you are making a decision about who to vote for? How many times somebody has violated the act, or how much the person was charged as a penalty per violation?
I think it's how many violations that's important to me. Because if it's a continuous thing, it turns into a pattern. And it's just a continuum. And I would imagine more than likely it would turn into other things, possibly criminal in the future. Because my interpretation of, if I can get away with this and be on a pretense that I'm unaware, these actions were in the past, I've got a bad memory of that, it goes into a whole bunch of different directions. And you have other people looking, and you're setting an example, and it's a bad example that you're giving to everyone, what you can do and what you can get away with.
Thank you.
Okay, thank you very much.
There's some additional public comment that we need to move on to. Thank you, sir.
Thank you very much for having me speak. Thank you.
Saw a couple more hands.
Hello, my name is Charles Calderon. I'm a resident of the City of Commerce. And last night, 4 Commerce residents, Richard was one of them, we drove 8 hours to be here today at this important meeting. We were going to urge, or our goal was to urge the commission to please, move forward with a default decision in the matter of City Commerce Councilwoman Tina Baco del Rio. Tina Baco del Rio has repeatedly abused her position on Commerce City Council. We believe Tina Baco del Rio has voted against the interests of the people of Commerce, and we believe in violation of the Brown Act. That is why Commerce residents today are gathering hundreds of signatures to petition the Los Angeles District Attorney, Honorable Jackie Lacey, to investigate and file criminal charges against Tina Baco del Rio for continuous campaign violations, disregard of California state law, abuse of power, and improper elective behavior. I thank the commission for your time and your consideration. Thank you very much.
Thank you, sir. And I see another hand.
My name is Abelardo Rodriguez. I represent a group of people who are going door to door in the city of Commerce, trying to inform the residents of what's going on in the city council. Also, we put a letter together, and I'd like to read it. Dear Madam Chair and Commissioners, I write to urge you to move forward with a default decision and order in the matter of Tina Baco del Rio, Friends of Tina Baco del Rio, and Tina Baco del Rio for Commerce Council, 213 FPPC case number 12/832. The facts of the violation have been investigated and presented to you. Tina Baco del Rio has repeatedly abused her position on the city council, Commerce City Council. We, the residents of the city of Commerce, have been complaining about Tina Baco del Rio abusing the city car use policy for years. She only stopped violating the policy when Brian Hughes of Hughes Media News wrote a few newspaper articles on her misuse of city vehicles, which led Tina Baco del Rio and her colleagues on the city council to pass a $500 a month car allowance and a cell phone bill allowance. However, Tina Baco del Rio continued her misuse of the city vehicle policy while collecting the $500 car allowance. In essence, double dipping until additional newspaper articles were published. Keep in mind, the city of Commerce is only 6.2 miles. In addition, the city clerk who originally reported this problem to you, the FPPC, was forced to retire shortly thereafter. So was the deputy city clerk. Both were longtime city of Commerce employees. In your previous settlement agreement with Tina Baco del Rio of April 2011 for campaign reporting violations, FPPC number 8/423 for $26,000, we the people did not get any disclosure on her campaign contributors, which raised questions on the many projects she voted on. Was Tina Baco del Rio voting in favor of her campaign contributors? When will we the people know or get disclosure on who is paying the large amount of money for these fines? Most of us do not have $55,000 just sitting around the house, nor can pull $55,000 to get in about 30 days. Tina Baco del Rio has displayed a history of blaming someone else for her mistakes, or makes herself out to be the victim. She can produce tears on request. Will the FPPC make recommendations to the DA's office to pursue criminal proceedings against Tina Baco del Rio for illegally using campaign funds for personal use? I am sharing this with you to demonstrate that Tina Baco del Rio has exhibited a constant pattern of abuse of her authority. Once again, I urge you to move forward with the default decision and order and help stop this ongoing pattern of abuse and disregard for the law. Tina Baco del Rio is making a mockery of the system. Tina's been doing this for a long time. She was the running mate of Robert Furo, who was indicted and was sent to jail for this. But in this court document, she was only called his running mate. So I don't know why he was covering for her. but this was back in June of 2009. Here I also have a list of things she's had her hand in with the city council. One of them that comes out that really comes out is the Washington Boulevard construction firm is a massive 80% over budget. It adds 1.1 million to the project. We don't know what happened to that money. We're thinking that maybe it went into the wrong hands. Also, I got this letter from she sent a letter to the FPPC saying that she didn't really know what was going on. She's a very shrewd person. She has a lot of legal resources, even though she doesn't make a lot of money. In fact, the only money she makes is from being on the city council. She does pretty well. We wonder where all that is coming from. Tina has created a new wave of corruption. Commerce has been victimized by city council corruptions in the past. We try to, citizens try to get rid of the people who've been involved in the corruption, but it just keeps coming back. And Tina is she's endorsed 3 other people who work with her on the council to whatever she needs, they vote with her. And we, like you've heard before, where do we get anybody that lives in the city of Commerce get that much money? Most people, even with 2 people working in a house, make less than $50,000. Who would want to give her $1,000 and give her other, I would say, 1, 2, 3 council members any money to run? That would be $1,000, $4,000 just for one person. She does have people who can back her up. And this latest thing with her reducing her fine to $15,000 and then the $40,000, we really want to know where that money came from, because we didn't hear about anything that she did to raise that money. Thank you very much.
Thank you, sir. You can leave your letter that you read if you'd like, and we can post it with the item online.
Okay. Thank you.
I want to give everyone an opportunity to speak, but we need to move on as well. So go ahead, please.
Gloria Mesa Huancoyo from the City of Commerce. I did have something in writing, but
Would you like to submit your statement in writing?
no, I'm just gonna say it now.
Okay, thank you.
As briefly as possible. I said, Tina Vaca del Ria's known income is only from the City of Commerce. That's all her known income. So I wish I could get a copy of whatever affidavit she got saying where she got her personal funds. Her known income, and if the whole city knows that, it's less than $25,000. So there's no way she could raise whatever you're asking her to pay for for personal funds. There's no way that she ever loaned herself $15,000 for the campaign according to the paperwork. And there's supposedly there's 2 loans on the papers out of her own money. It's a family of 4, 5, but I'm not sure if the oldest daughter still lives there. But with no income of $25,000, there's no way. There's no way. And the paperwork is incorrect. There's a big perjury document right there. Okay. Also, claims of innocence. No, you cannot claim ignorance or not knowing how to complete the paperwork. The city clerk kept reminding everyone, we got one report for every time that they needed. She kept asking her to submit the paperwork. Everybody else did. Everybody else submitted the paperwork correctly. She did not bother. The same way that she did not bother to answer you until the last minute when she panicked. That's the last time she did. Okay? It's, I reminded her, I will ask her at the council meetings, what has happened. When are you going to pay the fines? When are you going to file? And she said, no, not say anything. And I said, well, according to the newspaper, your paperwork is still late. Oh, the paper is, it's a yellow paper, raggedy paper. They don't know what they're publishing. So now, thanks to the 500 pages, we know, hey, the newspaper was right. It's coming up. Now it's coming up. we're learning more and more of what you did, and now it's being verified. So when you said the 24 counts, I do want to see all the 24 counts, if you pile it up, all the yellows together, and not, yellow or pale yellow, if you're going to put all the colors together, I still want to see them, because people in Commerce need to know. I said, and how did she come up with all this paper and all this money in 30 days? I said, there's no fundraising. She's been hiding from us. She missed city council meetings. Hey, where's the donor? If you have a piece of paper saying that the people on Newport Beach and City Newport, whatever, it's contributing all this money, let us know. We want to know who's behind Tina Vaca del Rio and who actually is running our city. Okay, we don't have the means or the subpoena power to ask. We just depend on the residents, their neighbors, tell us what's going on in there. And I'm really sad for the decision that you decided to go with, because she deserved to be with the full punishment for 100,000 and all the counts. Because otherwise, we're going to be here in 2-3 years on the next election, because she's still not going to learn. She got away with it the first time with $20,000. She's getting away with this one, and she'll be back. She'll be back here, and we'll be back complaining. But if we don't have the subpoena powers or the money to hire an attorney to chase her. She does have her friends covering for her, but okay. So I'm sorry, I wasted my last 24 hours coming here for your decision.
All right, thank you. Thank you. Any additional public comment? Okay, seeing none. Do the commissioners have any more questions or comments?
I think we do over here, but do you want to? Okay. Madam Chair, this is Commissioner Wasserman. The first thing I want to say is I want to echo the statement of appreciation for the citizens who came up, the residents who came up to articulate to us what their concerns were. They're very powerful statements. But I think I can speak for each of us as a commissioner in deliberating on this, that we'll only really consider the aspects presented that fit issues within our power. I think there was a lot that was said that is outside of the jurisdiction, the purview, or even the consideration of this commission. And I just want to make it clear for the record that those really aren't, while I appreciate the statements, those aren't going to be the facts that I will base my vote on. It will be the portions of the statements that relate to the issues specifically before us as to the counts, the number of counts, the evidence, and the appropriateness of whether to accept a stipulation or deny it and seek to impose something else, whether it's the default arrangement we had prepared to proceed on or some other intermediate position. But I will say that I was taken a little aback by the statement suggesting that the personal funds were not actually personal funds. And frankly, because we don't usually have as much public comment on an issue like this, I'm curious to ask Ms. West what exactly we do with that. This is public comment. This isn't sworn testimony. But it at least, presents a doubt in my mind as to make me to wonder. Maybe it's not. How do we take these public comments?
This is Galena West.
As an evidentiary question.
It is an evidentiary question, and generally the statements from neighbors about your financial well-being are not necessarily accurate. So we generally take the evidence that you provide us and give it a little more weight. But we do listen to everything that comes in, and which is why in this case in particular, we did ask for confirmation of actual documents that we could see from bank accounts that showed a balance that already existed, that had withdrawals for the payment of the fine. So if she knew 60 days before now that she needed to deposit money into an account, and I'm not going to disclose any information about the account, but if she knew that ahead of time and put money in there from someone else in anticipation of participating in the process, I would be surprised.
But yeah, so I mean, that's the challenge, right? Someone comes up and says, based on the information they have from whatever source, whether it's attempting to extrapolate from other disclosure documents, statements made, things that we don't have presented to us necessarily in a form that we can evaluate. It's troubling,
right?
But I'm not really sure, you know, how hard to bite down on that.
I don't think you should.
But the issue is once we have made a decision, say we approve a stipulation, say we don't, but say we approve a stipulation, and subsequently someone makes a complaint which actually has some documentation or sworn testimony that says this person's annual income is X. This fine was Y. We know that they have a house. Public records show they have this property and a mortgage. This is a hypothetical. I don't know what the circumstances of the respondent are. And they present evidence that whatever we approve in this stipulation, that wasn't the personal fund. What's our recourse?
I want to make sure.
Do we have recourse?
Interrupt you again.
And I'm thinking back a little bit to Detrick about what recourse we have after stipulation has been entered to return to something and say, hey, something in that was materially false, and
if you're talking about,
if there were otherwise an agreement between two parties, something materially false, it can be set aside. I don't think that's the direction that we ended up in the past, and that's what concerns me and makes me wonder how to address these kinds of statements in the future, whether it's more appropriate to conduct further inquiry to be absolutely sure. Well, I shouldn't say absolutely, because that opens up the door. There's no absolute truth in these matters.
right.
Or we proceed based on sworn statements of the respondent, the bank statements that have been reviewed.
Right. So Commissioner Wasserman is only speaking about this case in particular, where we have reviewed the evidence and it satisfactorily leads us to believe that this was paid with personal funds, which is what the requirement is. And if the issue comes up later to where someone can actually give some sort of credible evidence to us showing that that was somehow forged or the bank provided us incorrect evidence, which I find difficult to believe. I think in this case, you should be reasonably assured from senior counsel's review of the documents that were provided to her that she is confident enough to present it to you as a payment of personal funds, which is why she felt confident enough to write that in her exhibit. Otherwise, then if enforcement's evaluation of the evidence is not enough, then I don't know where to go from there. I guess we'll have to have it.
And if down the road, some citizen comes forward with a complaint saying those funds were her personal funds, but the source of funds was a loan or a gift, that's a separate violation issue, right? That's not a question of reopening this stipulation.
Right, that would be a new complaint that we would evaluate at that time.
Right, and that's.
Right.
Commissioner Wasserman, that recent change to the statute in the Garcia bill that said that it just specifies in 89513 that campaign funds may not be used to pay a fine arising out of personal use. It doesn't say you can't get a loan. Yeah, it doesn't say you couldn't use your credit card or get a loan. It's just, it can't be your campaign funds. So it's not a big difference, but it is something to know.
Sure. Yeah, I mean, there certainly would be other sources for the funds that would still be considered under the statute as personal. I was really saying more along the lines of if hypothetically, for any particular candidate, if it turned out that a loan or a gift were made by an individual, not something that sort of, you know, someone went to their line of credit or their personal obligation. But you know, the other thing I did want to say, because I think even though, you know, I have some real concerns about all this, and I'm sure the chair was going to articulate this, and perhaps I should let her, where we are debating and our disagreement is between two levels and approaches to enforcement on matters which have now been stipulated as actually done. I mean, that this is not going to be the difference between someone getting away with something and not getting away with something. So I think we're all pretty much going to be in agreement on that this is, so I just wanted to make that point as well. Where I vote is where I'm going to vote, but wherever way this goes, this respondent has been called to the floor for her violations, and it's going to be a question of degree.
Correct. So I'm gonna move us along unless there's any other, okay. I just want to clarify one thing for the record, and I think that goes to your point, Commissioner Wasserman, and just to the public in general. This isn't a vote between 100,000 and the default and the 55,000 and the settlement. The default is off the table because right now what we have before us is a settlement and acknowledgement of serious wrongdoing with a very high fine of 55,000. If the commissioners reject the settlement, we don't have the default in front of us anymore. That's been removed from the table by entering into a settlement. What we would do by rejecting this is send this back to enforcement to, I guess, try to enter into another settlement, go to a hearing and contest this matter, and to hope to get better than $55,000, and then hope to be able to collect it. So I just want that to be clear that this isn't an either or.
Wait, Madam Chair, may I ask a question about that procedurally?
Sure.
Okay. So, I mean, on the agenda, what we have before us is really a yay or nay on the stipulation. Is that correct?
Correct.
So in that sense, I suppose the default isn't agendized for today. But my understanding from the last meeting was that we were not, by entering into negotiations, even in proceeding towards stipulation, which is subject to commission approval, that we were not giving up our ability to impose the default.
That was let me just clarify, that was, the issue was, she showed up, said we had a tentative agreement. These are the terms of the tentative agreement. If that agreement did not materialize, the default would remain pending because there's no other option. But as you can understand, Mr. Wasserman, Commissioner Wasserman, sorry, it's enforcement's motion for a default that they're putting before us. Once they negotiate and enter into a settlement with the party, they can't also say, by the way, you can also opt for a default. So the default was going to remain if we weren't presented with a settlement. Now that we are,
okay.
Yeah, so now that we're entered into a settlement, our option is accept or reject and send it back with the hopes that some other resolution could occur, or again, they would take it to hearing, and I guess ultimately, if she failed to participate, maybe down the road we'd be back at a default again. But that's obviously, as I started out about an hour ago saying, I don't think the preferred method, because we don't have an acknowledgement of wrongdoing. We do not have money in hand. Not that this is only about money, but this is $55,000 paid. If we go the route of the default, we would have to pursue collections. I'll just point that out. Commissioner Nguyen.
Hi, thanks very much. First of all, I'd like to thank the public very much for coming today. Your input is very valuable. I support this stipulation I'm going to move for approval in one moment, but I do just want to acknowledge this is a very serious case, one of the most serious we've had in 3.5 years. It's one of the highest penalties we've had. We've gotten her to agree, to this, so she has acknowledged wrongdoing. And even though we did kind of have a stutter step on counts, every single item that we were going to charge originally is stipulated in this judgment. It's, kind of clustered and categorized, but, we have gotten a lot with this stipulation, and I support the staff wholeheartedly. And with that, I would like to move approval of this stipulation.
I'll second.
Commissioner Adero,
No.
Commissioner Wasserman,
No?
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion does not pass.
No, it's not. It's, well, I can let Hyla speak to it, but since it takes 3 votes to either approve or reject, this stipulation is basically in limbo, and I'm going to continue it until the next hearing so we can have 5 commissioners, and then we can break the tie that we find ourselves faced with. Does that sound correct, Hyla?
Yeah, that's correct. It takes 3 commissioners for commission action, so it's neither approved nor, it would just be to the next meeting.
So we'll hold it over to the next meeting, or to the meeting where we have 5 commissioners so we can resolve the vote. Okay, so we'll move on to item 4.
Sorry, Madam Chair. So how Ms. Wagner was saying, when because we had this issue before, I think on district round 1 or whatnot a while back. So 2-2 means it is not approved, but enforcement is free to bring it back the next month. And then it was addressed by the commission at that time. Right?
Right.
A failure to approve is not a denial.
It's not unless it would be 3.
So we take 3 to reject.
For commission action under the regs or the statute and on commission action.
So we're going to bring it back next month so we can talk about it again. And hopefully, if we don't have 5 commissioners, we might just, Okay, so that will continue. In the meantime, we got to move on here. We got item 4. Commissioner Wasserman?
Yes. All right. So we began to talk about this, and so this is a true source, or I guess we refer to it as a campaign laundering case, in which the individual made 2 contributions of $700 to a campaign committee. Both of those contributions were made in the name of other people, which I guess were his family members, whose names are not set forth in this stipulation, but may not be necessary. So there are 2 questions I have. Let me ask for that sort of the simpler one. I read in here that this case was referred to enforcement by Oakland Ethics and also resolved any claims pertaining to over-the-limit contributions under the city ordinance. As a mechanism, how is that working? How does that work? Because that's not within our purview, right?
This is Galena West. Actually, this is an interesting case because this came to us as a referral from them when they were just starting. They had just passed their ordinance. They had 1 person on staff and they had noticed this, and so they referred it to us. And their statute of limitations is much shorter than ours. I believe it's 2 years. And so they were beyond their statute of limitations. They couldn't act on the case by the time they were fully staffed. So we gave the respondent some peace of mind by putting in that there would be there's no other resolution to this other than this is the end of it for him. We generally do that so that people, we work with the locals, as you know, on a regular basis, all the ethics commissions, the DA's offices, because we try to have every resolution to be global so that no one has something else pending over their head after enforcement action is concluded.
Yeah, okay. I'm a little confused by that, because if we don't really have the power to resolve over the limit contributions, then we don't have that power. And if the over the limit contribution violation alleged is past the statute, then this is surplus.
It is. It's a stipulated settlement, and when working with respondents, sometimes that we put in language that doesn't harm us, and we worked with Oakland Ethics to make sure that the language was good with them, and they were fine with it, and we were fine with it, and that's why it's part of the stipulation.
I'm going to think about that while I go to my next question. So here we have, I think, and Ms. West, I appreciate you pointing to this earlier as maybe a clearer example for the discussion about how we address more generally the seriousness of violations and the whole count and fine issue. But without going into, again, the larger policy question, I would say specific to this case, I see two distinct acts of a serious violation, making a contribution in the name of another, and so that would be my basis for not voting in favor of this stipulation. I understand that well, actually, I don't know. Did the respondent make, that we know of, make a contribution in his own name as well?
It doesn't say it, but since it's on a public document, I can confirm that he did.
Okay.
So,
I'm just curious.
This policy discussion that we're having, I would just like to make one more point. And,
sure.
And I think that what is being missed in determining this is the value of the evidence. You have to think about these as stipulated settlements. You have to think about these as there's a reason that things are dropped, and there's a reason that things are combined. And I can't tell you all those reasons. I can't go into things that are beyond this stipulation, and that is uncomfortable. And I understand that it's difficult for you and it's difficult for me. And that's what's hard about stipulated settlements. I can't speak on behalf of the respondents because that would be ex parte. I can't tell you the reason why an evidentiary link is weak. I can't tell you why something is not something we wanted to go to hearing on. I can't tell you that a witness is crazy. I can't tell you that the person would come off very well because they're a terrific liar. I can't tell you these things, but you have to rest assured that this is part and parcel of coming to stipulated settlements. We have to be able to evaluate the evidence and the strength of the case, and we have to give things up sometimes. And that has to happen. And really, we've caused our own problem because we put the information in there for you now. We never, the practice of commission of the Enforcement Division for 20 years was to only tell the commission the things they charged. So we never used to release complaints. We never used to release probable cause reports. You would never know that we never charged something. And now we put all that into the stipulation. We show you the underbelly, which is great that we have discussions about it. And it's great that we now have the power to make these decisions to give direction. But please keep in mind, the reason that you have this information now is because we're trying to be more transparent. We give out the complaints. We give out the probable cause reports. So you can compare a probable cause report after a case is issued. The newspaper can run it and say, in probable cause, we believe there was a reasonable suspicion to believe a prudent person would come to the conclusion that we could prove 12 counts. We'd settled for 7. That doesn't mean we can approve in 12 at a hearing. That means that we thought 7 was the right amount that we could prove, that had the strongest evidence, that showed the actual harm that determined the right resolution for the case based on what is the priorities of the act. We look back at that 8100 section of the act all the time. If you read our exhibits, it has that in it. The reason why transparency is so important, the reason why we do this every day and we get out of bed. So I really hope that when you're having these discussions, you will keep in mind that there's a whole other side of this story that we can't tell you. We can talk about it in defaults because there is no represented party that we are talking ex parte. But when it comes to a stipulated settlement and you read the facts, the black and white, that's all the information that I can give you, unless that other person comes and wants to also speak. So I just hope that that is kept in mind as we have these further discussions, because there will be no way for me to be 100% transparent with all the facts of every case to tell you why something isn't charged.
That's entirely fair. And I actually appreciate, that was a really fantastic explanation about the issues related to discretion and charging, et cetera, which I think are really useful, particularly for the members of the public who are present. Because I think you know that I know, and I think the other commissioners know that there's a lot more that goes into these things than just here's what we charge, et cetera. And that we put value on evidence, we put value on uncertainty.
I think we put value on our chief of enforcement and her entire staff, and we have to have a certain level of confidence and support for these stipulations. Otherwise, I fear we're going down the road with this type of in-depth scrutiny on counts and the like, to making it more difficult for them to fulfill their mission. That is my concern.
Well, I understand that concern, but I don't think we're going there. I have a great deal of respect for what Ms. West and what her colleagues do, and I understand in this context it's a little I don't know if I can possibly say unique, but it is very different because they're bringing this to a commission that has oversight and decision making, and so we drift into policy and then back and forth, and it certainly becomes uncomfortable. I don't think we're going beyond our range, and I certainly don't want it to make it the appearance that we discount the effort that goes into it, the professional standards that are applied, the experience and expertise. Otherwise, we would probably be having much more of these discussions than we have. I mean, these are not frequent discussions we have on these things. So I don't think we're falling into that pit. And I think it's perfectly healthy for us to ask these questions about the policy. I do think Ms. West's point is very well taken about stretching from the facts set forth in the stipulation. And I will endeavor not to ask questions that are not directly related to what we can actually talk about, such as we can actually talk about, well, has something been paid? And was it paid out of personal funds? Because that's germane to the acceptance of the stipulation by the commission. So again, whatever determination I personally make with respect to an individual case, I don't want there to be any misunderstanding about my appreciation for the difficult nature of these investigations, putting them together, putting together the charges, evaluating the evidence, and then presenting it to a commission. So I hope that's not the impression that's being made, because it's not what's intended. But nonetheless, when I look at this particular one, I am empowered to disagree, and I'm one vote.
Okay, any more questions or comments? Any public comment on number 4?
Wait, Madam Chair, this is Maria, Commissioner Audero, and I do have a comment.
Okay, go ahead.
Before we go to public comment. I echo everything that Commissioner Wasserman has just said. There is nothing that has been said by me today or that I've heard by anybody else that in any way devalues the work and the effort and the trust that we have in our enforcement division, and any of the other leaders of the commission and the staff. To the extent that it's being characterized that way, that is absolutely not the intent. And I think that that has to be very clear. So if it's not clear with what I'm saying and with what Commissioner Wasserman is saying, please let us know now, because we want to make sure that we don't close this meeting with that up in the air. That said, I also agree with Commissioner Wasserman that we do have the ability to ask questions, and there are things that we recognize that can't be discussed. But I view prosecutorial discretion as different than the discretion to reduce number of counts once they have been prosecuted. So the decision as to the number of counts that are brought and that are made public obviously is something that the enforcement division has the final word on. It is their discretion. But once those counts are brought and then they are reduced in order to reach a stipulation, I do believe that we are entitled, and the public is entitled, to information about why the reduction was taken. And I think that the reports that we receive are very well written. I think that they provide a lot of very, very helpful information, and I thank the enforcement division for that, because I know it takes a lot of work to put these reports together, and they do many, many, many per month, in addition to all the investigative work that they have to do and everything else that's on their plate. So, but the information, as has been the practice, does have to be there, and we do have the ability to question and comment on that. And I think that's been the subject of the discussion today. Just to be clear, not so much whether the enforcement division has the discretion to decide whether to bring a count, but rather, once it's brought, what happens to it to reach a stipulation. So I just want to clarify that point. All of that said, I think that the enforcement division does a wonderful job, and we are very, very lucky to have the people in place who are leading it, Ms. West and her entire staff.
Any other comments? Commissioner Wynn?
I'd like to move approval of item number 4.
I'll second.
Commissioner Adara,
Yes.
Commissioner Wasserman,
No.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, so that's it for enforcement. Thank you, Ms. West. We will move to item 15, which is the regulation.
Chairman Recchi and Commissioners, Brian Lau, Senior Counsel. I'm here with Hyla Wagner, General Counsel, and I'm here to propose the amendment to Regulation 18751. Under the Act, every agency is required to adopt the Conflict of Interest Code, and Regulation 18751 provides the Commission's procedures for requesting an exemption from the requirement of this requirement and approving those requests. This regulation applies to agencies for which the Commission is the code reviewing body. These are state agencies and multi-county agencies, and the regulation also encourages other code reviewing bodies to adopt similar procedures. This proposal is a continuation of our attempts to streamline the Act's Conflict of Interest Code provisions. As you recall, at the April meeting, we have adopted Regulation 18750, consolidating and simplifying the procedures for the submission and review of the required codes. In drafting the proposed amendment, the primary objective was to address the readability of the prior version. Hopefully we have accomplished this, and overall we did not stray too far from the substantive requirements. Just to quickly address these changes, first we made some minor revisions to the standards for requesting an exemption, including language that implied that an inoperative agency would still have to seek an exemption, and clarifying that the existing standard for boards with no decision-making authority is really just criteria for determining when a board has no other designated employees. The second thing we did, probably one of the most significant things, is that the proposed language no longer requires the supporting documents, but requires it if the documents are requested. This replaces a more complex scheme that required agencies to provide different documents depending on the type of request or the reason for the request. Ultimately, the documents now currently required are not always necessary. We can oftentimes make the decision based on their stated reason and the statutory authority which they are still required to provide. In other cases where the supporting documents are needed, nowadays the documents are pretty readily available online. Third, we have replaced existing approval timelines with the cross-reference to section 87303, which is nearly identical to the current requirements. It gives the commission 90 days to approve or deny or return a request, and if returned, it gives the agency 60 days to resubmit. Finally, we have slightly extended the date to request reconsideration of the exemption from 30 days to 30 days after it's been posted on the website. The website posting requirement is still there. This just gives the public a full 30 days to object if there happens to be any delays in posting it online. So with that, I recommend the approval of the amendment, and I can answer any further questions.
Thank you, Brian. I think it's a really good job, very clean. I think it's the direction we want to go in. Any other questions or comments from the commissioners on this regulation proposal?
Madam Chair, I just have one question.
Okay.
What is the sort of universe of entities how many entities are we talking about that seek these exemptions?
It's actually rather very few. I think since March, I think we had about 3 or 4, and we've had requests for exemptions and about 4 requests for extensions. So it's not a large body of agencies requesting these.
Right, there's a
Thank you. I'll just echo that it's very clean.
Yeah, there's a couple examples in the memo of the International Trade and Investment Advisory Council, the Governor's Military Council, another review panel. Yeah, we note that the regulation is like 3 pages instead of 6. It's more plain language, and it streamlines the substantive requirements. It has headers, so it's much easier.
Thank you.
Any public comment on regulation 18751? Okay, I don't see any.
I'll move approval of this regulation.
And second.
Madam Chair, is the motion to repeal the current and adopt the proposed, or is it simply just?
Yes, as stated in the memo.
Okay.
Commissioner Adaro,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
All right, thank you, Brian. Okay, item 16 is the legislative update.
Good morning, Madam Chair and Commissioners. Philip Hong, Legislative Director. Sorry, I'm adjusting myself in the seat. Sounded like I fell over, but Madam Chair, I want to take a moment and just run through the bills and their current status. Many of them have their locations changed in the status. I want to make sure the commissioners are all working off the same update.
Are we just talking about the first 5, or what are we talking about?
I'm happy to just update the first 5, but I can also just, I was willing to run through.
Let's just focus on the first 5, and if anyone has questions on any of the others, we can go to those in detail.
Okay, so let me quickly run through their current locations. AB 700 is now on the Senate floor and was amended yesterday, which we will continue to discuss. AB 2002, it was referred to Senate Rules Committee. Let's see here. AB 2558 has passed the legislature and now sits on the governor's desk. And Mr. Hertzberg's bill, SB 1349, is on the assembly floor and received some technical amendments that do not concern staff.
Okay. So as you said, we'll talk a little bit more. You said that AB 700, number 1 on here, the advertisement disclosure bill, has received amendments. Those were just amended on August 17th.
As of yesterday, yeah, it's in the newest amendments are in print as of this morning.
Okay, so would you like to give us an overview?
Yeah.
Because as you know, right now it's opposed.
Right.
We are significant concerns.
We are opposed unless amended. That is our current position, and since we took our position earlier in the year, I felt like we were making significant progress with the sponsors in crafting compromise language that would get us to a place that we could possibly go neutral. As the bill was in the Appropriations Committee and on the suspense file, it passed out of the Senate Appropriations Committee with amendments. The source and the content of the amendments were unknown up until earlier this week, Tuesday to be exact. And once we got the content of the amendments, we still don't know where the source of the amendments came from. It did not come from the sponsor. Understanding it can come from anywhere within the legislature. And the amendments, unfortunately, go backwards as regards to several provisions that we thought we had negotiated into the bill. Madam Chair, would you like me to highlight those sections, or do you want me to stop there?
Well, I will just, I've had an opportunity to review the amendments, and I think, as you stated, they go in the complete opposite direction of what we were hoping for. Not only do I think this version is worse than the prior version, I think this version of the bill is worse than current law. I think the earmarking language is far too narrow and complicated, extremely problematic for us. I think this is the opposite of increasing disclosure, as I understand that the sponsors seek. This would really limit who has to be disclosed if this language is adopted. I'm really perplexed by why this would have been accepted, especially in light of the goals of the Clean Money Group. It doesn't make any sense. I see Trent's here. I don't know if you're going to speak, Trent.
Yeah, I do.
But so, I mean, to me, and again, I know some of the other commissioners may not have had an opportunity to read this in detail, but really just to hit some of the key points. I mean, our original concern was that the bill used the language about earmarking in advertisement disclosure, which was inconsistent with existing law, which prohibits earmarking. And so there was this problem with whether or not it was an implication that earmarking is okay as long as you disclose it on an ad, and it was different than the standard for what is prohibited. We suggested just clarifying what's prohibited and saying you can't do it. Anyhow, what we have now is earmarking defined basically three different ways. We have under the prohibition, which this bill narrows what is considered earmarking. We have it under what would be in the advertisement disclosure, which is different but similar and also very narrow and will not increase disclosure of contributors from current law and may actually have the opposite effect. And then we have a third definition in existing law under the multipurpose organization section, which is also different and broader. So, I mean, not only is this just, I think, really poor drafting in the sense that you have one term used three different ways and three different purposes. As I said, and I can't stress enough, this is going in the opposite direction of what the sponsors and people are claiming about increasing disclosure, and will narrow disclosure after time. This commission in the state has worked so hard to shed a light on dark money. And I think that this would really be going backwards and allowing dark money to seep back into California. As someone said earlier, it's wolf in sheep's clothing.
Yes. And Madam Chair, our Commissioners, Philippong, we, at this time, staff isn't recommending that we change our position. We believe it's still opposed unless amended. But at this point, the legislative cycle, there's no way they can amend it and still get it out in time for the session to end.
Well, to that point, Mr. Ung, I really think we should change our position to oppose. If they've lost the window to amend,
yes,
to get the bill, to, you know, in a way, in a position that we could support, I think we should consider changing our position to oppose.
I mean, in effect, it is opposed, because like you say, they can't amend. I'm disappointed that the amendments went the opposite direction after we and Phil had spent so much time working. And I understand that the sponsors have been, working with you and trying to cooperate and come to a mutual agreement. Again, though, this is kind of 360 or 180.
Right. And some of the issues with the amendments aren't really on the specific provisions, but really how the process of the amendments were developed. Usually when amendments are developed and we have questions about the nature or the meaning or the intent of the amendments, we're able to ask the drafters. As I mentioned, those drafters haven't come forward. We don't know who drafted these amendments, and so we're not sure exactly what their intent is with some of the exemptions. I would characterize them as loopholes were put into the newest bill.
I just wanted to clarify one thing on the procedure. So just for the commissioner's benefit, the Political Reform Act requires any legislation that would amend the act to be in print for 12 days before being voted upon. So although the session technically ends at the end of August, and so other bills will be being amended up until the very end, the Political Reform Act deadline is basically today, right, Phil?
That is correct.
Commissioners Odero, Wasserman, do you have any questions for Phil on AB 700?
None from me, thank you.
I'm in agreement with Commissioner Wynn if that's going to be useful at this point. Though I think whether changing from opposed unless amended, will that have an impact given the window? Otherwise, I would say let's do that. But does it have an impact?
I think I would agree with Commissioner Wynn that we should move to just a solid opposed, because I believe that it would be in our best interest to update our letter regardless, because to highlight the concerns and how this bill has moved in the wrong direction, and again would be worse than existing law for our purposes of trying to prohibit and prevent laundered campaign contributions and increase disclosure. So if the commissioners, if that's the will, I would agree with moving to just a solid opposed.
No, I'd be in agreement with that. I think if we were talking about expertise, I do turn to Commissioner Wynn quite frequently on the legislative and regular areas where she has a great understanding of the implications of taking positions. So I would certainly second that motions that were made.
But before we make an actual motion, I'm going to let Trent. Trent, is your organization the sponsor of the bill?
Yes.
Okay, go ahead and state your name, please.
I'm Trent Lang, President of the California Clean Money Campaign. We are the sponsor of AB 700, and we have been working with Bill on amendments for the bill. We have taken a number of the amendments. We did recommend to Appropriations Committee staff to take more of them. They did not take them all, unfortunately. However, I would say two things. First of all, we as sponsors, whose goal very much is to absolutely make sure that the public understands the true funders of ads. And currently, we do not believe that they do, because the current law earmarking rules in 85704, which is really the heart of this bill, are rarely, if almost ever, applied. First of all, they only apply to particular candidates. They do not apply to ballot measures or committees, including general purpose committees. They only apply to particular candidates. And the only time that we ever see these earmarking rules apply is in cases like Act Blue or in very extreme and egregious cases. The goal of this section and the bulk of this 85704 was taken from the Voters' Right to Know Act, which the commission worked with on. The version that was in print in June 30th was exactly word for word from that Voters' Right to Know Act language. The amendments that went through the Appropriations Committee only changed it, we believe, relatively modestly. But importantly, it broadens it to cover specifically identified ballot measures and committees, which 85704 currently does not do.
But I think you're mixing apples and oranges on the narrowness of the earmarking provision. Yes, that is narrow to the candidate issue, but that doesn't allow someone to avoid disclosing the true contributor under the rules requiring disclosure of contributors, because we have other provisions, including you can't make a contribution in the name of any other than your own. So I mean,
Sure.
but to narrow in on this one provision and say by adding something, this bill is good, you're missing the point. And your language, which you say just changed it a little, changes it enormously from if there's an agreement or an understanding to an express agreement. We have to prove an express agreement to launder campaign contributions in order to prove this.
I'm sorry, 85704 does not refer to express agreement. That's another portion of the bill which does not affect the money laundering provisions of 85704.
Specifically identified committee requests the contributor to expressly consent to such use.
That's in only response to solicitations. Subsection 2 describes any contribution made subject to a conditional agreement with the contributor that would be used to a specifically identified committee ballot measure or committee. There's no express in there, and that's the broadest section that's probably most akin to the current one. Subsection 1, which you're referring to, is an extension which gives you additional enforcement abilities.
But even in that subsection, you've taken out understanding. It used to say condition agreement or understanding. So now it's more like a condition or agreement, like they're going to have a contract to forward this contribution. And that's just never the way.
Sure, but current code 85704 only refers to condition or agreement also. So we are not narrowing current code 85704. We are expanding it by making it also include ballot measures and committees, and elucidating other places like subsection 3, which allows you to prove it after the fact if a subsequent agreement was reached, which again is not in current code 85704. We are broadening the cases in which you can apply this law. That was our intent.
Right, I understand your intent, and again, I have no problems with, I believe your intent is a good one, and I understand your goals. I think language that both general counsel and chief of enforcement have serious concerns with, which we saw yesterday, in the final 2 weeks of the session, and we haven't even been able to possibly go through and fully understand the implementations, but it's clear there is problematic language, and you also change it to specifically identified committee. What's the use of specifically identified? I mean, that's problematic. And then, can you address subdivision C, which is completely new?
Subdivision C is because of the fact that 85704 under this wording will actually become useful. It will apply in many, many more cases than current 85704, which I think that staff will acknowledge is very rarely ever applied. This
Wait, what was that? What's narrow?
I said that current law earmarking in 85704 is so narrow to a condition agreement to a particular candidate that is very rarely actually used. It's used in cases like Act Blue, clearly, but it doesn't seem like there's a lot of cases where we're seeing enforcement actions in those
It
cases.
seems that there's some disagreement with that characterization of how often or useful it is. But again, so subdivision C, which again is completely new, last minute, no opportunity to fully analyze it. To me, it seems like a giant loophole for basically earmarking contributions up to $7,000. And this is going to be a flat, they're not considered earmarking.
The purpose of that was because 85704 significantly broadens the cases where these earmarking rules will be applied to specifically identified committees and ballot measures, which are not covered under current 85704. There was concern amongst member organizations that it would, the purposes of our bill is to make sure that disclosures on ads, which are only the $50,000 threshold or more, are purposely tracked through the multiple layers, which this does in cases that current code does not. There was the idea to not cause a lot of additional counting and earmarking in small donations.
But see, the problem is, you just said this was added, subdivision C was added in an earmarking to help you on your ad disclosure. These are, again, two different issues. You have earmarking under the earmarking section for advertisement disclosure. Here, how is this a positive step when it says that members can give to their membership organization up to $7,000, as this says, for the purpose of making contributions or expenditures, and those shall not be considered earmarked. Even if they are earmarked, we shall not consider it earmarking. I don't get how that's not a huge loophole in the law.
We're looking at, we're asking you and everybody else to do is to look at the overall picture in terms of the disclosure that the public needs. A5704 as drafted significantly broadens the cases of earmarking. 2 ballot measures, 2 campaign committees that are where we're talking about multi-million-dollar donations and earmarking in general. We don't think that it is useful to, and that would provide an additional significant burden potentially to organizations if they had to track all this new earmarking that is not in 85704, nothing about ballot measures, nothing about campaign, specific.
But perhaps there is a concern. I'm not going to deny there may be a concern by broadening this at the last minute of the legislative 2-year session, but to put in a giant loophole with no qualifications that just flat out says any amount up to $7,000 per individual for the purpose of contributions will not be considered earmarking. I just don't even understand how that goes to your goals at all.
The goals are to make sure that on political advertisements, where there is a threshold of $50,000 for even in current code to be displayed, for contributors to be displayed on ads, to make sure that that is what the vast majority of the public sees. The vast majority of the public does not go to the Secretary of State website. That in those cases, the information that they get is accurate and reflects true earmarked funders. A $7,000 threshold does not impact
But see,
that.
again, you're mixing 2 ideas, and whose language is subdivision C, I guess the question is, because someone has an interest here that is being pushed forward. I mean, you have a whole section, 84501, which goes to your goals. Advertisement, marking, top contributors, tracing back, fine. I don't agree with it because there you use the term express. But why wouldn't you put any concern you have regarding getting to people you don't care about anyhow over there rather than broadly creating a giant loophole under earmarking?
Because in the top contributor section that you're referring to, that earmarking is only even comes into play when it's one of the top 3 contributors that may have received earmark funds. So it's applied in a much more narrow area. 85704, the laundering part, that's crucial. That's the real heart of what I would say the bill is. The top contributors part isn't even necessarily.
But when was 85704 even added? Wasn't this added like 2 times ago?
85704 was added 2 times ago.
At our request, with completely different language. So I mean, I guess I'm having a hard time understanding how now this becomes the heart of this 4-year bill.
We have always wanted to include the 85704 from the Voters' Right to Know Act, that the commission was a part of those negotiations.
Right, but not this language. Let's just be clear, not this language at all.
The language that was in print on June 30th was actually that exact language, and C is definitely a significant addition to that language. Addition to address the concerns of stakeholders about additional tracking and accounting, things that are unnecessary for the purposes of disclosure on political ads, because nobody that gives under $7,000.
Not unnecessary for the purposes of investigating an earmarking case. That's the problem you're missing. You're saying it's unnecessary for your purposes, but you're missing it is necessary for an investigation on laundered campaign contributions. Okay, we're going to just disagree, and you and I can go round and round, but I think this is part of the problem of having such significant amendments on August 17th.
We definitely wanted the amendments to become sooner ourselves,
but so, I mean, and I can go on, there are more concerns with the bill as now currently drafted. So we'll state those in our letter because that's all we have time to do now. But
I would just ask in closing, these earmarking sections and the rest of the bill are a broad expansion of your current abilities to track in cases where you currently cannot, because ballot measures and committees currently are not under your purview at all. These, not in section 85704.
Right, not under that section, but we still can pursue launder campaign contributions in any of those forms. So it's just because we can't use this section doesn't mean it's not under our purview.
Well, they're not tracked in a way that allows them to be done under section 84302 intermediary tracking. So I believe this is an expansion. It does have a couple pieces. I hope you look at the full picture, because currently political ads are not disclosure are not very useful to voters. This would make it much more clear the other provisions, in addition to broadening to ballot measures and committees.
Okay, but I'm afraid someone's been bamboozled here, because I do not think this is going to give you greater disclosure.
We respectfully disagree, but thank you. Okay. And we look forward to working with you as much as we can.
So, is there any further public comment on AB 700? Did you want to make a motion?
Yes, I would like to move that we change our position on AB 700 from oppose unless amended to oppose.
I will second that. This is Commissioner Wasserman.
Commissioner Adaro,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
All right, thank you. Do the commissioners have any questions or comments on any of the other legislative matters or questions for Phil regarding updates? What does AB 2002 going to rules mean?
I wish I could tell you.
I think Commissioner Wynn could tell us.
I asked Mr. Dunn about this right before we came in, and yes, I think that means we found a nice resting place for the end of the session.
Yeah, we're not exactly sure. It was sent to the floor and then subsequently referred or pulled from the floor by Rules Committee. Mr. Stone, who's the author of the bill, his staff has indicated they're not sure why. It seems to be an anonymous request from a senator to pull it into Rules Committee. If they are pursuing amendments.
Yeah, what's the amendment issue at this point?
Well, the amendment issue is they needed to have amendments in print by today in order to meet the 31st because of the 12-day waiting period. And so if they're going to make changes to the bill, it needed to happen yesterday. Unless they are taking out portions of the bill that relate to the Political Reform Act, at that point the 12-day would no longer apply to the bill. Whether or not they're doing that, I'm not aware of any such thing. So over the next 2 weeks, the bill could move back to the floor and have an up or down vote without any changes made to it. But at this point, it resides in the Rules Committee.
And the companion, well, it's not really companion bill, similar bill on Coastal Commission.
Yeah, there was a related bill, SB 1190, which actually was in the report because it doesn't affect the FPPC or the Political Reform Act, but it's okay. It's a bill that we are tracking nonetheless. That bill was amended today. Yeah, and those amendments are in print.
Where is it?
It's on the assembly floor.
Okay. All right, thank you. If there are no further questions, public comment.
I have two
Okay.
two questions.
Okay, Commissioner Wasserman.
Actually, one is a request. Commissioner Wasserman. Mr. Thank you for this. And although I can find my way to the transparency portal to look at the legislative history and reports and all of the different amendments, would you mind just adding that link back into future reports? Just makes it simpler when we're trying to just click and move around.
Absolutely.
And then with respect to this AB 2002, is there any need or urgency for the FPPC to alter its position similar to 700, or are we fine with where we're at?
Well, from a staff perspective, I think we're fine with where we're at, unless the commissioner would like to make a motion.
I mean, as you explained, it could be amended to take out the Political Reform Act provisions. So we're still hoping for that. So maybe this is a good one to keep as opposed unless amended. That's our goal, for them to take it out of the Political Reform Act. Right?
So it's differently situated than this 700, which we just went over.
Yes, AB 700 is completely housed within the Political Reform Act, where AB 2002 is split in half, where there's some of it in the Public Resources Code and some of it in the Political Reform Act. So they could remove the Political Reform Act sections and still have a bill existing.
Okay, I have nothing further on that. Thank you.
All right, thank you. We'll move to the executive staff reports. Any questions or comments? Commissioner Wynn?
Thanks. I just had two quick comments. Well, one question and one comment. Enforcement, great job continuing to move all these cases through. I mean, the numbers are baffling every month, so you guys are definitely working hard, I can tell. So thank you for that. And just a question on the Burgess case, which is my monthly question on the Burgess case.
Well, that's a timely question because the hearing is tomorrow, so Jack Woodside and Suki have flown down to San Bernardino for the hearing, and we're awaiting maybe a tentative ruling today. So
what time do they get the tentative?
I think in the afternoon, but we're just kind of clicking all day.
Just like jury duty.
Right. Thank you. That's my question and comment.
Okay. Commissioners, anything else, or can I submit the reports?
I have a couple of things. On Burgess, would you mind sending us the link to the tentative if and when it does come out?
Sure, I'll send that right away.
And then one request is perhaps maybe mid-fiscal year if we could do another update on the budget for the agency. That would be, well, I would appreciate it, but I understand we have to think of that well in advance for sort of staff allocation of resources. So that's simply a request, and I'll put out there for consideration.
Okay, thank you. So we'll look into that for mid-year. Thanks.
Thank you. And then the other two things I just wanted to say was thank you to, well, actually all divisions, but the two of the divisions that I think I've been relying on more often as of late have been enforcement and legal with respect to outreach that I get to do and refer, actually I do all three because I refer them back over to external affairs and education. A while back when I was speaking with before one group, Ms. West provided me with I think it was a top 6, not top 5, of the most common violations that enforcement sees. And so it's been very useful as a continuing bit of information as a preface to directing them to the external affairs and education and legal division to get opinions or information or the website and the videos, etc. So I want to say thank you. I thank you before when I got it, but since I'm still using it, I say thank you again. And again, to the other divisions that have been very helpful when I've had nuanced questions that have come up also in the context of the PRA revisions, which was a very interesting meeting that the chair presided over in Los Angeles. So thank you very much. That's all from me.
Thank you. Any other questions or comments? Okay, we'll submit the staff reports and I will move to adjourn.
Second.
Commissioner Adero,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
All right, thanks everyone.